We're going to start the day with number 166, People versus Durant. Counsel?
Good afternoon. I'd like 1 minute for rebuttal, please.
1 minute. You have it. Go ahead.
Janet Soames on behalf of Mr. Durant. We are asking this court to hold that where police conduct a custodial interrogation but
Let me ask you a question, counsel. I understand the issue very much so, and it's very much a policy issue in this state about electronic recording. What's the precedent in New York for some kind of a adverse inference charge or what you're seeking?
This court has repeatedly held an adverse inference charge to be appropriate in a variety of situations in different contexts.
Yes, but in this particular situation of a failure to conduct an interrogation and to not video it or electronically store it in some
Your Honor,
way.
I can't point to a particular precedent. However, the rationale underlying the adverse inference instructions that this court has required does support it in this case.
Tell us how so. Why in the normal course, certainly not close to all of our interrogations or most of our interrogations are being videotaped in New York. In the normal course, how does the failure to do so support an adverse inference charge in terms of the thought behind what an adverse inference charge is?
Because when the police conduct an interrogation, they are creating evidence. They're creating what is often the most powerful evidence that a prosecutor can put before a jury. When they fail to record the interrogation, they have created non-reviewable evidence. That puts the defense at an incredible disadvantage.
So if they don't record it, they can't use it, or they can use it, but they get a natural inference against it?
We are asking for the natural inference against it. This court has found an adverse inference instruction to be appropriate in cases where evidence has been withheld from one party by another, something that the other party has done. It's been to mitigate the harm or the damage done. This court has also said that.
Counsel, I'd just like to know, you said, you started to say that recording should be done only in custodial situations. Why only custodial?
That's all we were asking for at this point. This was a custodial interrogation. The police they control the situation in a custodial interrogation much more than they might control a situation out on the street. I'm not saying that we would never ask for an adverse inference down the road with body cameras and all, but right now we're asking for the adverse inference for the custodial interrogation only and in station house.
Your argument is that they create evidence because the police officer then subsequently testifies, or there's a written statement that comes out of this custodial.
Yes.
Right.
They've created the evidence. The evidence didn't exist until they actually do the interrogation, and then they don't preserve that evidence in a reliable and accurate way.
Well, they preserve it through, they don't preserve it the way you're requesting that it be preserved, which is through a video, right?
Accurate and reliable.
Fighting or so forth. But when they commence this custodial investigation, they don't know where the statements are going to lead, and of course your client could choose not to speak with them.
Absolutely. But there's no harm in recording it. And when they create
Well, you're not arguing this was a breach of their protocol.
We're not arguing it's a breach of
This is
protocol.
not intentional on their part. Are you suggesting it was intentional to avoid the existence of a recording?
I think it could be. That is, what the intent is.
Is that necessary in a case?
I don't believe so.
Counsel, but let me ask you a question, two questions. First of all, if you generally do video recording, and there are some places in the state where this has become, as a matter of policy, is being done, what happens then if you don't do it? Do you have a better case in that situation where they've said this is what we're going to do, and then for whatever the logistical or other reason or intentional, then you don't do it? Does that give you a better case in that situation if the norm is to do it and then you don't?
I think it's a good case in either situation, but if the norm is to do it, it certainly shows that they can do it and that there is the ability to do it. And when they
They can do it here. It's just in a different location.
They absolutely could have done it here. It's in a different location.
Aren't you demanding that they create evidence to benefit your client?
Absolutely not.
You're assuming it's going to benefit your client.
We're not. We don't know what it's going to do. The problem is that we cannot look and see what happened when
But neither could they when they made this choice.
But when the confession is then made the alleged confession is then made, and it's used as evidence against our clients, we cannot then look and see what was said. Whose words are these? Are these the defendant's words, or are these words that came
Counsel,
from the
but
police
the
officer?
second question I wanted to ask you is there anywhere in the United States where this is the case that if you don't videotape it, you get the equivalent of an adverse inference charge?
Yes, several states are going that way.
Which state? Yeah.
New Jersey, Massachusetts is the one that has created the adverse inference for failure to record. Other states are in
all
various...
kinds of cases, Counsel?
And I think it's on all felonies, but states are doing very, very different things across the board. Some are requiring it in homicides only or in
Doesn't
serious.
that sort of point to that maybe this is better for a legislative enactment?
Absolutely not, Your Honor.
Well, how would we set the parameters?
A custodial interrogation at the station house needs to be recorded.
Any level crime?
Any level crime. If the crime is important enough for the police to interrogate, it should be important enough for the police to record.
So at the time that this interrogation took place, apparently cameras or recording equipment was not that available, at least not in this city, right? They only had it in the public safety building for homicides and not on the east side where this crime occurred. But that's changing, isn't it? Aren't there, haven't cities and states, municipalities gotten money from, say, federal government and so on to get the type of recording equipment that you're now saying should be used generally?
Absolutely. I think the district attorney's amicus brief lays out very clearly what has been done to supply all police departments with recording
So doesn't that
equipment.
suggest that what you're asking for will happen?
Absolutely
or is
not.
happening?
Absolutely not. It may be happening in some cases, but it would still be up to the police to say when they're going to record, when they're not. We're asking for a rule which will incentivize recording in all cases. And my client is doing...
So it will require it despite the cost issues that might...
I'm sorry, I misspoke. We were asking for the adverse inference. So there are going to be times when perhaps the
But in
district attorney or
general,
the
it would
police...
become incumbent upon the police department to record all interrogations or certain level of interrogations if we were to find some kind of, make some kind of ruling along the lines that you suggest.
If they didn't, then they would,
Right.
they would
Suffer
get
the
the
consequence.
adverse
Well, it'd be
inference.
permissive, I assume. I
It
mean,
would be permissive, and there is no, right, it's the jury could hear what the,
Then they would have to put forward evidence as to why they didn't act badly, or the jury shouldn't decide.
They
to
would have that option.
Assess this as an
they would
adverse
actually have that option, and then they
Then
could
we
argue
have a
it.
mini trial in this criminal trial about their policy choices regarding whether or not to have recording equipment in all their stations, what their policy should be.
I don't think it would be a mini trial, but I think that it would be important because then the defense is on a more even footing here. Because right now, we don't know what was said, and we're suffering a disadvantage because of it.
if the legislature were entertaining legislation doing exactly this, should we be waiting for them?
No, you shouldn't, because what we know now is that wrongful convictions happen and that false confessions and fabricated testimony about confessions are a primary cause of wrongful conviction.
But the issue is that, assuming we agree with you that it is a positive thing to be able to, see what happened. This is a little bit different because you're almost making it, not quite. You're almost making it mandatory by saying if you don't, you're going to have in every case an adverse inference charge. So I guess that's the question in there. How does this translate to some kind of right to have it videoed, to have your interrogation? Can it be put in that framework of a right that you have, that if you're going to be accused of something, or if there's always an issue as to whether, what you did was voluntary. We started out with this. What's the rationale? Why should we find for you, and we know what you want, no custodial interrogations, how does it it figure in terms of the individual defendant and what he or she may or may not have a right to?
The individual defendant should not be convicted upon evidence he or she cannot see. And that is exactly what an unrecorded interrogation is. It is convicting on evidence that his attorney can't look at, can't figure out, what are the nuances.
What if this interrogation was recorded, for example, and there's one camera, and the camera is on your client as opposed to the interrogator? Then would we be hearing that, well, they should have had two cameras, or there should have been an angle where we could see the person asking the questions as well as the person who was answering them? I can just see a scenario where it would never end in terms of what would be the best evidence, I guess is what you're saying. What's the best evidence of this interrogation and what was actually said, and how the demeanor of each person involved would be captured or not captured on camera?
I think it would be very important to capture the demeanor of the defendant. Is he is he incapacitated? Is he distraught? What kind of signals you can get?
About the interrogator, what if the interrogator is making faces or signaling something, and you can't see that person on the camera?
I think that I think that we've got a recording, at least an audio recording of what happened, and so we're in much better position than we would otherwise. So where those lines end up being drawn, that's another case.
Okay,
probably.
counsel. Let's hear from your adversary, and then you'll have your rebuttal.
Good afternoon, Your Honors. May it please the Court, Jeffrey Kuiper for the people.
Counsel, why shouldn't this happen in every case?
I think in the abstract, it would be a good thing. Certainly.
It would be a very good thing. We have loads of cases here every day where when we can see it, we can make a much better judgment as to what happened than we're just going on, one side says so-and-so,
right,
and the other side says another.
Right. And there's no dispute that recording interrogations is a good thing. And there's been massive efforts undertaken by law enforcement, by the Judicial Task Force to bring this about. But it's a complicated problem. And I think that's reflected in the proposals.
Well, I can show you how complicated it was. We had a case about 6 months ago where the DA down in one of the boroughs was bringing in each defendant and saying, you're about to be arraigned. But this is, before you're arraigned, we're going to give you your Miranda warnings, and we're going to tell you this is the last chance you have to talk to us before and tell us what happened. And then they would give them the Miranda warnings, and then the guy would say, I didn't really mean to steal it, and we said, you can't do that. But it was a pretty sophisticated operation that showed the interrogator, showed the defendant, showed a clock, showed him getting his Miranda warnings. Why can't we do things like that? Not that complicated, it seems to me.
Well, there are serious problems with resources. We've made major efforts.
Well, I know enough about Rochester to know that the east side down to the public safety building is not that far.
Right, but there are a limited number of interrogation rooms that have recording equipment.
Got a cell phone? At this point, you can give a dozen reasons why you can't do it in high fidelity, but it seems to me that when you got a situation like in this one, when the interrogator was asked about the interrogation that he undertook, that the guy was cuffed, that he condensed what the guy said, wrote it down, and then had the guy sign it. Well, who gets to decide what gets condensed? Who gets to decide this is an important fact and this one isn't in a situation like that?
Right. So certainly it's the investigator who's naturally going to testify. Defendants do sometimes testify about their interrogations. That certainly happens and can happen.
But if in this case, if the defendant said, I tried to call my sister and I couldn't reach her, and that never made the statement and nobody ever found out about it, and then he testifies at the trial that he tried to call us, they'd say, well, why didn't you tell the officer that? And he'd say, I did, but it didn't make the statement. Who are you going to believe?
Yeah, well, I think you would testify to that at the suppression hearing, but
hypothetical.
Yeah, but I guess part of the problem with that is that is a limitless principle, and that goes to, I think, Judge Abdul Salam's question about the best evidence. That would be giving.
How about putting GPSs on cars? Do you think that's a good idea? That was a court-made law. We said you can't do that. It violates the Constitution. So we can make rules, and there was all kinds of excuses about why GPSs on cars was not a good idea. It was, limiting that. It would seem to me, most of the ones that we've gotten videotaped have helped the people.
Yes, yeah,
remarkably.
absolutely.
So I don't understand why this is a problem. You say it's complicated. I'm missing that.
Well, I mean, look at the proposals by the Judicial Task Force, by DCJS, the legislative proposals, which and something will pass very shortly. They limit the interrogation requirement to homicides and certain violent felonies. As a practice, there are lots of problems with.
So this happened, whatever, more than 7 years ago or so? Have things changed?
Yes, certainly. I mean, there's been tremendous development on this issue since then.
No, I'm sorry. I'm saying specifically where this occurred.
The
Is there the
Rochester
same
Police
policy in place?
The Rochester Police Department's policy is basically what the task force recommended: homicides, certain violent felonies. I think
That has not changed. What they did in 2007, 2008 has not changed. That's what I'm
I
saying.
don't believe that policy was formalized in 2008, but I beg your pardon, Your Honor, that I can't.
But let me ask you another question. The idea of this whole endeavor and everything we do in the criminal justice system is about justice. And I think I think the thrust of most of the questioning thus far, putting aside the ultimate legal determination, is that I think there's almost a consensus, prosecution, defense, and everybody else, that justice is better served if you videotape, record interrogations. If the whole game here is about justice, why wouldn't we say that if you don't do it, it's not that you must, but if you don't do it, then there's some kind of inference that says, gee, then maybe you're not really looking at justice. You're not trying to get justice, and if that's, again, what it's about, why wouldn't we do some kind of a finding that you have to do it, and if you don't, okay, there are cost issues, all kinds of things, but if you don't do it, then it hurts your case?
A couple of reasons. First of all, I think.
Is your answer that's not good for justice?
No. Well, I mean.
Go ahead, I'm kidding.
I think under these circumstances, an adverse inference would not be good for justice because, for one thing, you would be asking the jury to just sort of speculate. You can't.
No. You're going to have a judge, and someone's going to say, they didn't record this. And your officer's going to say, I didn't because we didn't have any equipment, and I had, it was expedient circumstances and everything, and the judge, I'm not going to give it. Done. Now you get another situation where maybe it's the opposite. It's not that the jury is all of a sudden going to be told, these bad cops are trying to do this.
No, but in this case, for instance, you would say, why didn't you record this? Because we don't record interrogations for Class C felonies.
Right.
That's the policy. So then you have to go into a mini trial about that policy.
Counsel, is this different from not dusting for fingerprints in every burglary?
I don't think there's any way to distinguish them. I think the defendant's position really is a limitless one.
Suppose he didn't write this down. Suppose the interrogator, when he did this, didn't write it down, but came in and testified to exactly what was in the statement. Would that be okay?
I beg your pardon?
He just comes in and testifies. He said, yeah, we had Durant in, and he told us what happened, and
sure.
and
yeah, and that happens.
Could defense counsel say, did you have a pencil?
Yeah, the defense counsel can certainly make that argument, and the defense made the argument.
And if
here.
they did, would they be entitled to an adverse inference charge if you get the wait a minute, if you get the investigator to say, I had a pencil, I had paper, I was sitting there, and I thought, I'm just too damn tired to write it down, and by the way, as far as I was concerned, there's only two things he was saying that was important: one, that he was guilty, and two, that he was sorry. Now, could you get an adverse inference from a judge that maybe that's not all he said, and maybe some other things he said would have been important?
No, I don't. I think the judge can give that instruction in the judge's discretion if under the circumstances that seems appropriate. Right. But I don't think it's a matter of law that the judge has to give that kind of instruction, because if you're going to go down that road, again, this is limitless. You're going to have adverse instructions on all kinds of evidence.
The adversary says you're creating evidence that benefits you. She says that's what's the problem with with the approach that you've taken.
But that's the same as dusting for fingerprints or something else. I mean, when you dust for fingerprints, you're creating evidence. I mean, if we can use that term at all, you're creating evidence in just the same way as an interrogation. Or when you go and knock on neighborhood doors and talk to witnesses, do we need to record those too? I mean, what if the officer's going to possibly lie about what that?
Wait a minute. I mean, you're making a joke out of this, and it seems to me.
I'm not trying to. I beg your pardon.
I'm almost done. It seems to me if you've got somebody in handcuffs who's facing liberty interest, that's a little different than knocking on somebody's door and say, "Did you see anything?" We're not trying to make it silly that the police officers that we know have a difficult job. The situation we're addressing is in the modern times with what all we have, and with the police able in murders to do this. Well, I don't know. I don't want to go away for 10 years. It's unfortunate, but you've got a D felony, pal, and so we're not recording yours. But the guy across the street, we are, because he's got an A felony. How do you rationalize that?
Yeah, and Judge, I apologize. I'm certainly not trying to make light of this at all. I take this extremely seriously, and that's why I think it's important that if we're going to entertain the legal argument that the defense is making, that we look at what the consequences of that would be.
All right, but if we do that, can you tell me why you do it for a murder and you won't do it for a serious assault?
Well, I think there are probably a number of considerations. First of all, you simply can't at this point record every police interaction with everyone on petty larceny.
You keep doing that.
So forth.
Let me pull you back a little bit. You've got a murder, and you say we have to record this, right? Police protocol. Okay. All right. Now you got a guy over here who's got some felony that you say we don't have to do it. What's your policy reason for saying this guy is going to get videotaped, and this guy we're going to write it down, summarize it, and have him sign it?
I think it has to do with practicalities of resources.
Money?
Money is one element of that, but there are also other issues with this. I mean, you have to then store all that material. You have to have procedures for you have who has access to it.
If somebody puts up the money for the garage, can you put this tape someplace?
I mean, I think
you can't say store it. I mean, you store your records on appeal. So do we.
I think if money and training and staffing and so forth, if none of those things were issues, I think we would have legislation today already.
I know, but the reason I asked you, money I get. All right, so then I would ask you how much is it going to cost. But you're saying, and then storage. All right, if you got storage taken care of, and somehow we found the money, or the legislature found the money, is there any other reason why?
I think there are complicated issues about how you're generating lots of data in lots of circumstances.
How's Massachusetts handling it?
I beg your pardon, but I can't answer.
I think isn't it a general consensus today, and that's why so many of and this is the last question, and then we'll go to rebuttal. Isn't a general consensus today that it doesn't cost very much because of the modern advances in equipment, and that's one of the reasons why it has become relatively not uncommon for these kinds of interrogations to be a videotape, because it's not a big deal today. I mean, the question is, and we get it, what you're saying, how fast you move to, that place when maybe all interrogations would be videotaped. But it is not that big a deal today, right?
It's becoming much less of a big deal, and that's one of the reasons that this is moving forward. And I think that's a good reason to allow the legislature to set the appropriate parameters for it, and that would not raise these problems of.
Okay, good. Thanks so much.
Just three quick
Counsel,
things.
We're moving in that direction, clearly.
Yes.
The police get it, prosecutors get it, the defense gets it. This is something that makes sense, and again, in terms of this concept of justice. So the question is, I guess I come back to the first thing I asked you is, should we be saying such a, in a way, a severe way of inducing this kind of videotaping all over the place? Should we be saying in a case as a matter of law that if you don't do it, there's an adverse inference? Is that the way we should be going, or is it more a policy issue and the trend of it is all very clear? And I think all partners in the justice system gets it. Why go the route and I understand your arguments for it, why go that route instead of letting it evolve?
Because the human cost of wrongful convictions is too high. And while we wait for the legislature to act, if maybe they will someday, who knows, and who knows what it'll look like, in the meantime, we know that there will be
Well, there are bills in
more
the
convictions.
legislature, in the Assembly, and the Senate, one by Senator Nozzolio of Rochester, right now.
Yes.
Have you looked at these?
A long time ago I did.
Assuming they were
Recently.
passed, would that satisfy your views with
No.
respect to this?
No, because there's no sanction for not recording, and we would then ask for the adverse
So-
inference.
Why can't you rely on the discretion then of the judge to ask, if we didn't say that it was required as a matter of law, but simply that the court can give that instruction in a particular case if it seems warranted by the facts and circumstances of that case? Why can't we rely on the judge's good discretion?
Because it doesn't solve the problem. It doesn't mitigate against the harm of a defendant.
No, the discretion to grant the adverse inference. That's what I'm saying.
Because this court has always held when an adverse inference is required that it's not the discretion of the court. And People versus Handy.
And this is the issue that is being dealt with in terms of legislation, and that what's the consequence? Certainly one of the things that the Justice Task Force and, everybody who's looking at the legislation is dealing with. But let me just, in a nutshell, I think I get where you're coming from. In the nutshell, your argument is that if there's one person who gets wrongfully convicted because of the lack of videotaping and recording of it, it's one too many.
That's a very, very high cost, yes.
Well, before you leave, though,
Yes,
I
Judge
mean,
Pickett.
Rochester's a pretty sophisticated town. I mean, it's good-sized, but what do you do in Orleans County or Lewis County or some of the smaller rural counties?
It seems to me that it is so easy and so ubiquitous to do it now that there's no reason that they should not have recording equipment there. As you said, there's all sorts of different varieties of recording equipment.
Let me just close it as a point of information. That's exactly the argument that is being made in the smaller places around the state, as you know, along the lines that Judge Pickett is raising, that, gee, it's easy to do it in the big metropolitan centers. And in some ways, matters how you look at it, maybe it's easier to do in the more rural areas. But that is the argument that's being made by police chiefs, in places around the state that, gee, hard to do in a very rural environment. I'm not asking you to give an answer. I'm just saying informationally that's some of the debate that's going on about it.
And we know that funding has been supplied.
Yeah.
Thank
Okay, Councilor, thank you both. Appreciate it.